We're continuing our trial analysis of the Alec Murdaugh murder trial with Carl B. Grant, defense lawyer. A lot to get to today when it comes to testimony. We just heard not too long ago the shooting call from that roadside shooting where Alec Murdaugh initially said that he was shot by a stranger, then later admitting to SLED that it was his cousin, Eddie Smith, the entire time. And also, in that call, Carl, admitting to financial fraud. What do you take of that evidence today, and how can this be harmful for defense, being that they're the ones who initially didn't want it to be used in the first place, but they brought it up?
Yeah. Sure. Yeah, this is going to be very difficult evidence for the defense. Number one, considering the fact that his credibility, now he's not testified, not exactly.
Not on, he hasn't taken the stand,
right,
but in a sense he has been entered into evidence.
That's exactly right. So the many statements he's made and we've heard, the jury has to weigh the credibility of those statements. And of course, now you have on the recording here a person who is an admitted liar. And that's going to go a lot into the value that they're going to give his statements and whether they're going to believe any of his story.
Well, and at one point on some of the video that we listened to today of a new interview, they asked him point blank, you know, about inconsistencies in his story. And he admitted, he said, well, I haven't told anyone the truth, you know, up until this point. So that is going to be a big issue for the defense to overcome. But Carl, this whole issue, and we heard it earlier in Greg's piece, I think it was, where Judge Newman, his ruling about even allowing this evidence, because he originally in his first ruling said it was a bridge too far for the prosecution and he would not allow it. He says, but then the defense came back around and built a road right over the bridge and thought they could dance with fire and not get burned. The judge certainly had a way with words, but how was that? I mean, is it a fair assessment to call that a big mistake? Well,
and sometimes trial lawyers make those mistakes. But of course, the defense counsel argued that he really did not open the door, but that's going to be something for an appellate court to decide one day in the future if this man is convicted. Once again, if he's acquitted, there is no appeal for the prosecution. That's the end of the case. But if he is convicted, then that would indeed be an appellate issue. But that's the thing, like I said, about cross-examination. You have to be precise, you have to be to the point, and you have to be short, because if you're not, then you're risking the possibility that you could open the door. And that's a big problem if you ever do so.
And back to the point of hearing Alec Murdaugh, not basically, but he did admit, hey, I was lying. I have not been honest. When it comes to the murders of his wife and his son at this point, how is the jury supposed to not believe that he didn't stage that crime as well and he was a part of it if we're hearing that he's admitting to staging another crime? And that's a very good point. Remember, he not only deceived the police, I guess you could argue to say he flat out lied to them. Of course, that's still to be determined in some respects, but here's the thing. He told them that he thought it was related to the boat crash. So that's misdirection. That's telling them something to make them think somebody else did this, and this is a matter of revenge. Somebody's out to get me and my family. Now that they've killed my son and my wife, my God, now they're trying to kill me too. You see? So that's a furtherance of the misdirection. And arguably, the prosecution really could have used 404B in that respect, because 404B not only allows, as an exception, evidence of motive, but it also allows evidence of a common scheme and plan. That, to me, denotes a common scheme and plan to deceive. So they could have argued that as well.
Let's talk about Dr. Chief Kenny, whichever way, Kinsey, I believe it was. Yeah, he has a lot of titles, a lot of credentials, and even as the defense started its cross-examination, he reminded Attorney Harpootlian, that he had testified for him before, you know, at some point. But when it comes to an expert witness and clear, compelling testimony, does it get better than what we saw him deliver in that courtroom today?
Well, first of all, when the prosecutor puts his implied stamp of approval on you, he's used them himself.
Yes.
When I say the prosecutor, the defense attorney,
yes.
He used to be the solicitor. When he has used you himself, then clearly that creates an issue when it comes to, well, why should this jury not believe you? The man who's cross-examining you has used them himself. So, yes, that's going to be a situation where the jury's going to say, we've got a guy with all of these credentials, all of this education, and those of us who do this business, we know Kinsey, okay? He's one of the ones that we don't like seeing on the witness stand. He gets on the witness stand, he's very good. He's likable by the jury, and he comes across as professorial.
He does.
He's up there like he's educating and teaching the jury, and we hate that. We don't want to see that. We want him to sit down as soon as possible.
Well, listen, he went through it, and as I was watching it at home, Billy, I said, you know what? If he taught science class, like our kids would be doing a lot better in the sciences, because he broke it down in a way that you could really understand, and every piece of his testimony, everything he had to say today was compelling.
Yes, I've cross-examined him before myself in murder trials, and we just try to hit him and let him sit down. Don't keep him up there long. The last thing we want him to do is to be in front of that jury with his stick, as he was today, teaching the class. The jury is the class, and he's the professor. That's a horrible situation to be in as a defense counsel.
Wow.
Something that stood out to me, though, the prosecution did not ask him about Maggie Murdaugh's footprints. Remember, there was conversation also at the beginning of the trial about Maggie wearing flip-flops and her footprints. They didn't ask her about that. So why bring it up and make a big deal about it in the beginning, but when you have someone who can testify to footprints, on the stand, why didn't they ask about that possibly?
That could be a mere oversight, but you would think they would have brought that up since they made such a big deal about it. But that's something that, I don't know, the jury's just going to have to think about that. Why didn't I bring it up when they made such a big deal about it before? Your exact point. They're going to have to think about that. I'm not sure why they didn't bring it up. I would chalk it up to mere oversight. Okay. When you're in the heat of battle, there's so many things that you're focusing on and that you're thinking about. When you sit down, there are 5 things that you wish you would have said.
Yeah. Absolutely, absolutely. So as we expect, the prosecution to rest soon, we'll see, because now this evidence being allowed has changed that timeline, right?
It has. Yeah, it has. Now, I would imagine the most essential part of that evidence has come out today. And I always say that in a trial, you want to end that trial on a high note. Boy, what a high note they're sitting on right now.
Yeah.
So they have to determine, what do they do now? Do they shut their case down, or is there more things that we just don't know about that they want to admit and offer to the jury? If so, then, and they think it's essential, then of course they would have to offer it and admit it in evidence. But if you got everything in, there's no better place to end than right now. But that's just me saying that. I'm not the prosecutor.
Right.
They have to make their own call as to when they want to shut their case down and rest their case.
Yeah.
Wow.
And then obviously continuing tomorrow at 9:30, the defense is going to cross-examine the SLED agent who interviewed Alec Murdaugh after the shooting, when he confessed that he was lying. Is there any way the defense can use what we heard on tape today to their benefit? At this point, do they say he was traumatized or he was sad about losing his family?
But you know what? That is a great question. But this is what, and Dick Harpootlian seemed to want to go there earlier today. But at the beginning of the recording, the SLED agent asked you, "Are you of sound mind?" And Dick Harpootlian says, "Yes, he is." I mean, his attorneys certified that. So how do they argue against that now?
Right.
The only thing that you could possibly draw as a defense counsel, what we heard today, is some form of sympathy. If you can possibly draw that in this case, right? The fact that the man was addicted to drugs, apparently had this serious addiction, I mean, that's the only thing that I can see that can possibly be drawn. And cooperation, of course, with the police, people like that as well. But again, we have to go back to the totality of the case, the evidence, all of the evidence prove their case beyond a reasonable doubt. Will they be firmly convinced beyond a reasonable doubt of the guilt of the defendant? And if so, they should convict. If they are not, then of course by law they should acquit. So that's going to be an ultimate decision.
All right. Well, it'll be interesting to see what plays out in court tomorrow, going into a long weekend, because Monday is President's Day. So no court will be held on Monday, and whatever happens in court tomorrow, the jury will simmer on that over the weekend.
That's right.
Oh.
It's going to be I know, the drama will continue, absolutely. Well, we're going to take a quick break. We'll be back, but we'll wrap up with Carl tomorrow.